Okay, we're being live streamed. And Rose, is there a have the attorneys divided up their time in any particular way?
Yes, Mr. Edge and Miss Mates are gonna split their half in time, so 10 and 10.
All right, terrific. Thank you.
Cool.
Is everybody ready?
Yes.
Thank
Can you hear
you.
me?
I'm gonna go ahead and let the attorneys in. I know y'all are all still connecting. I just want to say good morning, everybody.
Morning.
Good morning, Your Honor.
Good morning. Can you hear us? Okay. And my understanding is, Mr. Cassidy, of course, you're representing the appellants, and the appellees are going to split their time in half, 10 minutes and 10 minutes. Is that correct? Mr. Edge and Ms. Mates?
That's
Is that
correct.
right? Okay, terrific. Thank you so much. I appreciate it. I appreciate y'all participating this morning with us by Zoom. I'm going to go ahead and call the case, which is we're hearing this morning 08-20-00230-CV, which is First Trinity versus Milligan. And if it helps y'all this morning, your presentation, I want you to know that we have had the case briefed to us. Obviously, we've looked at your briefs, we've looked at the record. If that aids in your discussion with us this morning, so we're familiar with the underlying facts. With that, we also have, I'm hoping that y'all can see our timer. And so we have it for 20 minutes. And generally we have red, green, and yellow. Red meaning stop, obviously. Yellow means you're about 2 minutes. You got 2 minutes left. But with that, Mr. Cassidy, you may begin. Thank you.
Muted. You're muted, Mr. Cassidy.
Yes, we can't hear you. Thank you.
My apologies. Can you hear me?
Yes.
Thank you, Your Honors. My name is Eric Cassidy, and I represent the appellants, First and Trinity Supermajority LLC and Third and Congress Supermajority LLC. For the purposes of this argument, I'll simply refer to them as the supermajority. I think that should do justice to the argument today. But to the extent that you feel it's necessary for me to distinguish between one or the other, simply ask. As you know, we are here today asking this court to reverse the final judgment of dismissal and remand to the trial court for further proceedings. In the alternative, appellants are requesting that the court reverse and vacate the award of the attorney's fees and sanctions against them. We're asking for this relief for several fundamental reasons, but the primary reason is that the supermajority and the petition that they filed and the actions they took were made in good faith. And specifically, as the record shows, the supermajority was concerned that they were being systematically excluded from the trial court proceedings. Specifically, they were concerned that the limited partnership agreements that control the partnerships were not being followed, and that they required the supermajority to give its consent to any sale or liquidation of the partnership assets. These assets are two large, very valuable pieces of property in downtown Austin, Texas. And it's really that fundamental emphasis. Was the supermajority being excluded? Was the receiver complying with the contractual requirements of the limited partnership agreements that initiated this lawsuit? Now, of course, there's a second aspect to that. There was concern from the supermajority that the receiver and counsel for the receiver and counsel for MIDI had either had discussions prior to the receivership order being issued, or the receiver was not honoring his fiduciary duty to all the parties. Because from their point of view, of course, and the law is very clear, the receiver has a duty, not just to one side or the other, but to everyone. At that time, yes, sir.
Mr. Cassidy, if I can interrupt you, I think one thing that kind of bothers me is you have one court that appoints a receiver, and then your clients file suit in another court to basically challenge the integrity of the receiver, his communications with the other parties. It kind of seems like an end run on the first court. Why wouldn't all these issues be raised with the court that originally appointed the receiver?
Well, I think ultimately that decision was made, but it's not in the record what trial counsel's motivation was for originally filing this suit in a different court. So I really can't speak to the litigation strategy that they had or why that was done. Ultimately, though, you are correct. It was the court was actually consolidated with the other matters, and the trial court had the opportunity to review this petition. We also can't speak to the motivation or rationale behind the judgment to the extent that the court felt that this was an end run, and perhaps it did, but that's unclear to us in this particular record.
And kind of on another vein, if I could just ask you, we've seen the third Court of Appeals recent opinion that
Yes, sir.
nobody brought that to our attention, but we actually do our own research and found it on our own. Are there any facts that are stated in that opinion that could not also be found in our record?
That's a difficult question to answer because of the breadth of that opinion. I will say this, that the concerns that motivated the supermajority's petition were real, and at the time, the issues that had been determined by the third court in its recent opinion were still issues that were open questions. And the point of this petition was to get a seat at the table for the supermajority, to raise these issues in a meaningful way. For instance, the declaratory judgment action was intended to get some kind of legal ruling on the role of the supermajority, if any, in the sale of these assets and property. So although I'm not answering your question specifically, I'd like to point out that, yes, some of these fact questions before the court have been determined by the Third Court of Appeals, but at the time, when you look at this particular petition, these were open questions that concerned the supermajority a great deal. And that was—
But let me ask the question in maybe kind of a different way, somewhat from the standpoint, maybe this is an appellate nerd question, but if you have two related cases before the same Court of Appeals, they can take judicial notice of facts in each case. I believe there's authority for that. This is a transfer case, obviously from Austin. And so are we permitted to take judicial notice of the facts that are discussed in the Third Court of Appeals opinion? And I'm not asking you to agree that the application of the facts to the law, I'm not saying that you would agree with that, but just the facts themselves that are laid out in their memorandum opinion. Are there any facts that are incorrect?
Your Honor, I would have to agree with you. You do have the authority to take judicial notice of the fact findings from the Third Court of Appeals. And I would also agree with you that you don't necessarily need to reach the same conclusions or implications of those facts, but they are there, and the court has the authority to review them and accept or go in a different direction based on your review of those facts and the record here. Now, again, I would just emphasize to this court that at the time the petition was filed, many of these questions were open questions. And because of that, it's imperative that the court, in issuing sanctions or dismissing this case, actually had an evidentiary hearing. In terms of the sanctions, one of the fundamental issues is, was there an evidentiary hearing to establish the subjective intent of the supermajority? Because it is implied that these were done in, that this filing was done in bad faith. And yet there's nothing in the record that shows bad faith intent of either counsel at the time or the supermajority. And that's fundamentally unfair to my client, because the evidence in the petition and the evidence that they presented shows a good faith factual background. The question of what the supermajority's role was and the receiver's role with respect to the limited partnership agreements was a valid question. And that was their fundamental impetus for why it is that they asserted this claim. I'll put it this way.
If I could just interrupt you one more time, I certainly agree that under Rule 13, there would need to be a hearing. But under Rule 91A or the TCPA, does there need to be a specific factual hearing in, I guess, awarding the $75,000 in sanctions?
Yeah, ultimately $150,000 in sanctions.
Right.
And we would argue that there does need to be an evidentiary hearing. We would argue that Rule 91A really, in this case, because the issue was the right to petition, that the claims of the supermajority fell outside and therefore should not have been dismissed under Rule 91A. But we would fundamentally argue that yes, for this level of sanctions, there is a need for an evidentiary hearing. And that is really one of the more fundamental issues before the court today. There is no finding in the record that the trial court considered any alternatives. There are no specific fact findings in the record about the subjective intent of the supermajority. In fact, the record itself is void of any evidence that actually supports $150,000 worth of sanctions. And candidly, that is a draconian amount of sanctions when there hasn't been any real evaluation of possible alternatives to monetary sanctions at that level. We'll also say that under the Rule 91A, the reason we have sanctions, and we have briefed this, is for deterrence. And there was no finding prior to this particular lawsuit that the supermajority had done anything in terms of previous litigation or bad acts. And so if the fundamental purpose of sanctions under Rule 91A is deterrence, there should be something in the record that shows the need to deter, and especially to deter at the level that they did, sanctions of $150,000. The chilling effect of these sanctions is well known. Trial counsel, of course, ended up withdrawing both from the underlying litigation and from this appeal, precisely because of the amount of money that was sanctioned, and he was found joint and severally liable for those sanctions. So we believe that the $150,000 is excessive. There's no evidence that the suit was filed for an improper purpose. There's no evidence that the trial court considered lesser sanctions. And fundamentally, the issue of whether or not this lawsuit interfered with the other party's right to petition in a lawsuit is, I think, disproved by the actual petition itself. There is no request for an injunction. There's no attempt to stop the appointment of the receivership. Instead, what's being alleged in the underlying petition, which is typical for contested and controversial litigation, is that facts occurred outside the appointment of the receivership that the court should be aware of and take notice of. So it's not necessarily that they're not attacking, the supermajority was not attacking the right to petition. Instead, they're attacking facts and making allegations outside of the other party's right to petition. And at this stage in the hearing, there was no discovery. This is not a bare bones petition. And it's really typical of the kind of complex litigation that demands further development of allegations, good faith allegations supported by contracts and other evidence. It demands further discovery before a case is dismissed at this level. Now, we'd also argue, as the court is aware, one of the issues here is whether or not the affirmative defenses that were raised were sufficient at this point of the proceedings to justify dismissal. And the attorney immunity, as we have argued, we believe that the issue was properly alleged in the petition as to whether or not the attorneys or the receiver were working in a manner that was inconsistent with their client's actual obligations or rights. More specifically, the petition raises the issue of the receiver's compensation, and this compensation is tied directly to the sale and liquidation of the property. From the very beginning, the agents for the receiver contacted lenders and said they intended to sell the property. And that is exactly why the supermajority filed for a declaratory judgment action and asked the court to review whether the property could be sold without their consent. under the limited partnership agreements. So that is a good faith reason for the supermajority filing this particular petition. We'd also argue in terms of sanctions. As we have stated in our brief, the petition alone is not sufficient for the court to make the kind of findings and the large sanction award that it did. There needs to be an evidentiary hearing. At the hearing on the motion to dismiss, the trial court did not hear any testimony. No witnesses testified. Therefore, the other side did not meet their burden to overcome the presumption of a good faith filing by the supermajority. There is nothing in the record at that hearing that shows the state of mind of the attorneys or the supermajority that would show some kind of bad faith in this particular filing. And as we've also pointed out in our briefing, attorney argument is not sufficient to establish sanctions in this context. So our point of view is that the claims that were alleged at the time they were actually alleged were viable on a factual basis, and they were made in good faith with good faith legal causes of action. I'll address two more things before reserving the rest of my time. One is the issue of whether or not the supermajority is qualified to do business in the state of Texas. As we've argued in our briefing, in fact, that issue could have been easily cured, and there's case law and precedent supporting us. So that would not be a reason to dismiss the case at that time. And finally, I think the larger takeaway, if you read the judgment, is there's just this implied suggestion that the supermajority and its attorney should have known better than to file this particular claim or petition. But at the end of the day, there is a legal basis to file lawsuits against receivers or to request a declaratory judgment or to raise the issue as to whether the receiver is honoring his fiduciary duty to all of the parties. It is established that you can, in fact, file these kind of lawsuits. Now, what we are saying now, what we are arguing here is very, very clear. At that point in time, there was not a sufficient factual record developed to dismiss these lawsuits. And there certainly is not evidence in the record that shows the level of bad faith that would justify sanctions in this amount. And with that, I will reserve my remaining time.
Thank you. Appellees.
May it please the court. Good morning, your honors. My name is Rhonda Mates, and today I am representing the receiver appellees, which includes Greg Milligan, Steve Lemon, and myself. As Andrew Edge will be arguing on behalf of appellees Ray Chester and the Mitty Foundation. And I intend to address the Rule 91A issues, including, as Justice Alley so quickly pointed out this morning, why this case is an improper collateral attack on the receivership order. And I will also address the attorney's fees awarded. Mr. Edge will address the TCPA dismissal and sanctions. Since that was a good part of what Mr. Cassidy discussed this morning, I may take less of my 10 minutes and provide the rest of it to Mr. Edge, since he's covering sanctions. For the record, we each adopt each other's arguments. Everything about this case is outrageous. It's unbelievable. Mr. Lemon, Mr. Chester, and I have been practicing law for a combined 93 years, and none of us ever imagined we would be here today defending not only our clients, but ourselves as lawyers for doing our jobs. World class, and let's be clear, whether we're talking about the supermajority, the general partners, or any other entity with WC in its name, the org chart all starts and ends with Nate Paul, and he operates under the world class umbrella. So world class has proven that it will stop at nothing to derail the receivership. This case was an egregious attempt to intimidate the receiver, the Mitty Foundation, and us lawyers. Since Mr. Milligan was appointed more than 2 years ago, World Class has employed more than a dozen lawyers in this dispute alone to attack the receivership in every way imaginable, including 5 appeals, 2 interventions, 4 bankruptcies, 2 motions to vacate the receivership, 2 motions for new trial, and 2 lawsuits against the receiver, this being the most recent one which incredibly includes the lawyers. This information was all before Judge Seufer, who had assigned all of these cases, related cases, to her court. So that is information that she had when making her ruling in this case. As I said, Justice Alley nailed it on the head with his first question. This is an end run around the rulings in the receivership case. At the most basic level, this case is a collateral attack on the receivership order, and dismissal under 91A was therefore proper because there's no basis in law. The supermajority even admitted as much. In response to their motions to dismiss, the supermajority admit that had they asked the court to vacate the receivership order, that would be a collateral attack. Mr. Cassidy even said it again today. He said the supermajority petition did not ask to vacate the receivership. But if you look at the prayer in the first amended petition, which is at Clerk Record 85, they ask for that very relief. And I quote, "The supermajority asked that the court declare the receiverships null and void." So by their own definition, that's a collateral attack. Every single issue in the supermajority petition was raised in the receivership case, and it was raised in the Court of Appeals. And as the court pointed out this morning, the Third Court of Appeals has affirmed the appointment of the receiver and dismissed all of the remaining appeals related to the receivership. The final judgment does not specify the basis for dismissal. So if dismissal was proper for any reason, it should be affirmed. So to be successful, the supermajority needed to negate the validity of each ground on which the trial court could have relied. They failed to do so. In addition to having no basis in law because it's an improper collateral attack, dismissal under 91A was also proper for a host of other reasons. Under 91A, a claim should be dismissed for lack of basis in law under a couple of circumstances. If there are too few facts to demonstrate a viable cause of action, or if the facts as alleged bar recovery. All of the claims asserted by the supermajority fall into one or both of these definitions. The supermajority failed to plead all of the essential elements of the causes of action, and they failed to support the elements they did plead with facts. As this court noted in Aguilar versus Morales, threadbare recitals of the elements of a cause of action, supported by nothing more than conclusory statements, are insufficient to survive a 91A motion. To the extent the supermajority even attempted to state facts to support the causes of action, those facts are not only conclusory, they defy reality. Furthermore, last year, the Texas Supreme Court confirmed that an affirmative defense may be the basis for a Rule 91A motion to dismiss. Appellees demonstrated that all of the claims by the supermajority involved actions protected by immunity defenses, attorney immunity, derived judicial immunity, and absolute litigation immunity. These defenses were sufficient to bar all of the claims, and because the supermajority failed to negate all possible bases, the final judgment should be affirmed. And I want to circle back to the issue of attorney's fees before I turn this over to Mr. Edge, because I think Mr. Cassidy was a little confused on what was awarded on what basis. Attorney's fees were awarded under Rule 91A or the TCPA. The TCPA has a mandatory requirement of attorney's fees, and Rule 91 has a permissive provision for attorney's fees. The only requirement for that is that the fees are reasonable. There does not have to be evidence of bad intent. Mr. Wynn, the supermajority's attorney, was sanctioned in the amount of the attorney's fees under Rule 13 and or Chapter 10 of the Civil Practice and Remedies Code, which do require a bad faith showing. But as Mr. Cassidy pointed out, Mr. Wynn is settled. He's no longer a party to this case. So arguments of bad faith and bad intent are irrelevant to whether fees were appropriate under Rule 91A or TCPA. I'm happy to answer any questions that the court may have. Otherwise, I'm going to pass the baton on to Mr. Edge.
Let me ask you, Ms. Mates, one question, and then I'll ask Mr. Edge to address the same thing. I'm kind of hearing from the other side that there was no fact finding or hearing where all these facts about the history of the litigation and the appointment of the receiver and the delay over the weekend, when all of a sudden then they said the property had been sold, but then maybe it really hadn't. How were all of those facts in front of the judge when the judge made the decision to dismiss the lawsuit and award the sanctions?
In a couple of ways, Your Honor. First, the same judge was presiding over the receivership case, and so she had the history of the litigation. Under the abuse of discretion standard, I believe that she can take those facts, her personal knowledge, into consideration. Also, the response, our motion to dismiss, and the responses filed by the supermajority included sufficient facts to support such findings.
Okay, thank you.
Thank you.
May it please the court. My name is Andrew Edge, and I represent the Mitty Foundation and Ray Chester. Before getting into it, I just wanted to add one more additional point on that question. I just want to read a quote from a Texas Court of Appeals case regarding judicial notice, because I think that, Ms. Mates was getting to this, but that Judge Seufer could clearly have taken judicial notice of the facts in the record in the underlying receivership litigation in deciding to award sanctions under the TCPA, sanctions and attorney's fees under Rule 91A or any other basis. And here's the quote. It is well recognized that a trial court takes judicial notice of its own records in a cause involving the same subject matter between the same or practically the same parties. The court may take judicial notice whether requested or not. The trial court need not announce that it's taking judicial notice. The court may be presumed to have taken notice of its own files. And that's from Searad versus Barnett at 164 Southwest 3rd, 471, Penn site 481. That's the Texas Court of Appeals for Dallas. So getting back into it, as you've heard, this lawsuit clearly never should have been brought against the receiver or against the Mitty Foundation, much less against the attorneys representing these parties. In their attempts to justify their suit, appellants have never offered any legitimate reason for taking the extraordinary step of suing these attorneys. Mr. Cassidy this morning could not even articulate a reason why this separate lawsuit was filed. I'll be focusing on an independent basis to dismiss the lawsuit, the Texas Citizens Participation Act, otherwise known as the anti-SLAPP statute. The TCPA provides an early and potent defense against the sort of baseless and harassing litigation brought by appellants. Appellant's lawsuit was clear gamesmanship, an impermissible collateral attack on an ongoing proceeding barred by absolute immunities, including attorney immunity, judicial immunity, and the judicial proceedings privilege, as well as other defenses. The trial court recognized this, dismissed the lawsuit at the first opportunity, and properly awarded attorney's fees and sanctions. Appellant's appeal provides no basis to disturb the district court's judgment. Appellants attempted to raise several arguments never made below. Each of those are waived as detailed in our brief. On the other hand, their appeal failed to contest several issues that would independently support affirming the district court. After appellees raised these arguments in their briefs, appellant failed to respond to them even in the reply briefing. The myriad problems with the appellant's lawsuit and their attempts to justify it would take the better part of an hour to cover comprehensively. So I'll focus on a set of issues at the heart of this case, why the TCPA applies and how the district court properly exercises discretion under the statute in awarding sanctions. I'm actually going to take this in reverse order here, given the focus that we've already had on the sanctions award. When a court grants a motion to dismiss under the TCPA, it's required to award the moving party its attorney's fees and may additionally award sanctions sufficient to deter the plaintiff from filing similar actions. That's the standard, not this good faith standard. The trial court entered sanctions against appellants and their attorney under the TCPA of $75,000 each, awarded to Mitty and the receiver. It's important to bring some clarity here because appellants seek to confuse the legal standards governing TCPA sanctions with those governing other types of sanctions. When Mr. Cassidy refers to good faith, requirement for an evidentiary hearing, specific consideration of lesser sanctions, these are all requirements imported from separate legal standards not applicable to TCPA sanctions. A court is given wide discretion in determining the amount of such sanctions. Indeed, in all of the TCPA cases cited in appellant's brief, but one, the reviewing court upheld the court's sanctions determination. Contrary to Mr. Cassidy's suggestion for TCPA sanctions, unlike other types of sanctions, the district court sanctions award does not require specific supporting evidence and certainly doesn't require a separate evidentiary hearing. You can refer to this court's own decision in Robles versus Nichols for this observation. Also, the court's not required to provide any specific explanation for its sanctions award. That's found in a case cited by appellants, which is Kinney. However, case law has provided some non-exclusive factors that may be helpful to a court in assessing sanctions, including the plaintiff's financials, the amount of attorney fees incurred by defendants, plaintiff's litigation history, and any aggravating misconduct on plaintiff's part. There's no requirement that any one or all of these factors be established. But in this case, the district court had before it evidence relevant to each of these factors. It had evidence of the significant attorney's fees expended by appellees, of the partnership's stake purportedly held by the supermajority entities, which had been valued by their own expert at roughly $78 million, relevant prior litigation activity, and other aggravating misconduct. This court had evidence to suggest and specifically found that appellants were wholly controlled by Nate Hall and World Class, Mitty's litigation adversaries in the receivership litigation, and formed for the purpose of pursuing this litigation, which we contend was to harass and frustrate the ongoing legal proceedings and receivership. The court had evidence of the supermajority's prior improper attempts to intervene in ongoing litigation and of World Class's other litigation misconduct, including prior discovery sanctions, a swiftly dismissed bankruptcy, eventually swiftly dismissed bankruptcy filed as an attempt to evade a sanctions award and scheduled deposition, and the fact that the arguments raised in this lawsuit had been previously raised and rejected in the receivership lawsuit. This latter factor was specifically recognized as relevant to sanctions in the Kinney's case cited by appellants. The court knew that appellants had taken the extraordinary step of suing Mitty and the receiver's attorneys with their various baseless and ill-defined claims. Most jarringly, Ms. Mates filed a receiver's report on compliance and then was promptly sued a few days later. This further established that the lawsuit was being used as retaliation and harassment, not to advance a legitimate objective. Because of the extensive evidence of misconduct, coupled with the large financial power of appellants in World Class, the trial court properly exercised its discretion in awarding sanctions to deter future litigation abuse. Now I'm going to return back to the threshold determination that TCPA dismissal is available for lawsuits that are based on or in response to a party's exercise of its right to petition. This includes any communication in or pertaining to a legal proceeding. The district court correctly found that appellant's lawsuit is based on appellee's right to petition under that statute. It's apparent from the pleadings in the record that the suit was brought in response to Mitty seeking the appointment of a receiver in the underlying receivership litigation. Appellants attacked the process leading to the appointment of the receiver and the actions of the court-appointed and supervised receiver. Their arguments are cloaked in the language of conspiracy, misconduct, and self-dealing. Those allegations are false, but more importantly for this analysis, they're irrelevant. If a litigant could avoid TCPA merely by bare allegations that the manner in which his opponent exercised his right to petition was wrongful, then the statute's protections could be easily pled around, frustrating its purpose. Robles also provides a good discussion on this point. Further, appellants suggest that the portion of their lawsuit complaining of communications between Mitty's attorney and the receiver's attorney that took place outside of the courtroom and before the appointment, therefore didn't implicate the right to petition. This is incorrect under the case law. A party exercises its right to petition not just by making filings with the court, but in other activities pertaining to presentation of its legal arguments and seeking relief. For example, courts have found that court communications like an attorney's email to an escrow agent and conducting preparatory witness interviews were exercises of the right to petition under the TCPA. So it was proper for the court to find appellee's communications pursuant to and in furtherance of seeking the receiver's appointment exercise the right to petition and are covered along with all of the other communications and behavior challenged in appellant's lawsuit. Once the district court found that the TCPA applied, dismissal was a certainty in this case. To survive TCPA dismissal, appellants would have had to provide clear and specific evidence supporting each element of their causes of action. A review of appellant's briefing below and their arguments at the hearing shows that they completely failed to meet this burden. They failed to even specify which of their claims were being asserted against Mitty and Mr. Chester, much less proffer specific evidence to support those claims. And even if they had made that evidentiary showing, the trial court would have still properly dismissed their claims, as it found appellees had to establish defenses entitling them to judgment against appellant's claims. Appellant's arguments against many of these defenses, such as the attorney immunity and derived judicial immunity, are wholly unpersuasive. The court should also note that appellants failed to even raise an argument on appeal regarding, for example, the absolute privilege that Mitty Foundation and its attorney enjoyed for statements made in or related to judicial proceedings. This defense alone would entitle Mitty and Mr. Chester to dismissal. And since appellants have made no argument on this score, the district court's dismissal must be affirmed as long as this court finds that the TCPA applied. I'm happy to answer any of the court's questions, but overall, the district court's judgment should be affirmed. Thank you.
Thank you. Rebuttal.
Thank you, Your Honor. Briefly, Mr. Edge just said that in our opening argument, we did not say why this separate lawsuit was actually filed. Ms. Mates started her argument today by trying to say that the supermajority and world class and Mr. Paul, they're all the same thing. That's fundamentally untrue. The only way that you can accept those arguments is if we totally ignore corporate form. The supermajority is a distinct entity. There is nothing in the record that says the supermajority is equivalent to any and every world-class entity. And that is precisely why this lawsuit was filed. The supermajority, as you know, owns over 80 and 90% of these assets. It had no voice in the litigation. And the impetus and the reason that this lawsuit was filed was so they could have a seat at the table. It's not a collateral attack. It would have been a collateral attack, perhaps, if someone like World Class or someone else who was already involved and under the receivership order had filed this lawsuit. Instead, the supermajority filed a lawsuit and asked for a declaratory judgment to determine its rights and whether it had a say under the limited partnership agreements in whether or not these assets should be liquidated.
But I mean, Mr. Cassidy, I mean, correct me if I'm wrong, but weren't the supermajority entities created during this litigation, really kind of at about the time that there was a dispute over the supersedious bond, and that then the assignment of the world-class entities was made from them to the supermajorities and all kind of signed off on by Mr. Paul, when all those facts have been in front of the trial court?
That is both partially correct and partially incorrect. Yes, the supermajority is contemplated in the limited partnership agreements. That is part of the agreement itself. They are referenced in there. But you are correct that the entities were created after the limited partnership agreements were signed. Could this have been in front of the judge? Perhaps, but it's not in the record. It's not listed as any reason for the ruling that she made. And it certainly doesn't justify $150,000 in sanctions. These are separate legal entities. There's been no finding in any court that they are non-existent or that these entities themselves should be disregarded. That's simply untrue. But that is exactly what the opposing side argued. I'm sorry, I got a little feedback there. Can you hear me all right? Okay. So second, when you ask the question of why this lawsuit was filed, it was to protect the interests of the supermajority itself. And the court could have just as easily allowed discovery to go forward and made a ruling under the declaratory judgment action that no, in fact, the supermajority did not have any rights under the contract. That was a legitimate question that they need to have answered. And without filing a lawsuit, the supermajority had no venue or avenue to determine its rights under the limited partnership agreements. So it was a valid and good faith filing. Second, as you can tell from this oral argument, yes, this has been contentious and controversial litigation. But I would invite the court to, again, revisit our reply, because many of these claims that they make about litigation are not as they would have you view them. For instance, the bankruptcy court filing, they asked the bankruptcy court to find bad faith. The court never went to that avenue, never made that finding. Instead, the bankruptcy court simply said that there wasn't sufficient authority for those claims to go forward. And I think if the court looks at our reply, looks at the record as a whole, you will see that many of these claims that things are so outrageous and all that aren't really supported by an objective review of the record. At the end of the day, the fundamental question, if this court decides to allow these sanctions to stand, are these sanctions reasonable? Is there sufficient basis in the record to support $150,000 in sanctions? What is the role of sanctions under the TCPA? It's for deterrence. It's not intended to be punitive. And any suggestion that $150,000 in sanctions is not punitive is simply unsupported by the record. We know the result of what happened with those sanctions. The attorney who was representing the supermajority withdrew from this case, from the appeal and the underlying cases. If we allow a court to simply issue $150,000 worth of sanctions under any rule or under the TCPA or not Rule 91 or any sanctions provision, there is an absolute chilling effect on a party's ability to retain competent counsel and representation. It is a slippery slope that this court should end here. And with that, I'll be happy to answer any questions.
Any further questions?
No.
All right. Mr. Cassidy, does that conclude your rebuttal?
Yes, it does, Your Honor.
All right. Well, thank you. We appreciate your participation again today. The case will be submitted on your briefs and argument, and hopefully we'll get something out to you as soon as we can. So thank you so much. We appreciate it.
Thank you, Your Honor.